Well, thank you, Shona, and well, hello to you all. It's nice to be back here in my own study speaking to you all. Um, Today, there's a number of cases we're going to chat through. Some are a bit longer than others. But I was going to start with a case that first I actually called about a year ago today. I remember it very well because it was the day after my son's birthday, which is also the day that the Queen died. But the outcome of the case, which is an unreported decision from Glasgow, is rather a startling decision for insolvency practitioners, because it involves the issue of whether or not if a spouse grants consent, in terms of Section 113 of the Bankruptcy Scotland Act 2016, whether that consent can actually be withdrawn. And the background to this case was that there were two debtors, a husband and wife, both were sequestrated in October of 2017. At a reasonably early stage in the sequestration, I think both had granted consent in respect of each other's sequestrations, and therefore the trustee had the ability to sell the property that they lived in. I should say that they owned the property in joint names. The case had gone on for some time because I think the wife had said that she was waiting for an inheritance to come from her late father's estate, and the intention was that that would settle the sequestration in full. But as is often the case, that didn't happen. The agent for the IB was being given a number of excuses, and so eventually decided to press the button and proceed with an action to have the two defenders ejected. What happened was that the proceedings for recovery of heritable property were commenced. Action called at Glasgow Sheriff Court. Interestingly, the husband did not defend his action, but the wife defended her action. And on the morning, she instructed, I think it was CLA, who are one of these charitable organisations who help homeless people and people facing eviction. They came along and we said, well, you don't have a defence to this because the Section 113 consent has been given. And the answer to that was, well, actually, no, Mrs. W is going to withdraw that consent. So, no, you can't do that. In any event, the case called before Sheriff at Glasgow, and after having heard submissions from us and also heard submissions from counsel for the Mrs. W, decided that in fact consent could be withdrawn. And the reason why he took that view was because he said, well, if you look at the terms of the consent wasn't said to be irrevocable. He also thought the word consent could be given its natural meaning. That is to say that if you consent to someone, you can always withdraw your consent and change your mind. And in any event, he said the accountant bankruptcy, or the trustee rather, has got a remedy, and the remedy being that he can always make an application to the court in terms of Section 113. And so on that basis, he held that the accountant bankruptcy didn't hold consent, and the case was then for further procedure. Now, I disagree with that decision, I have to say, for a number of reasons. Firstly, if you look at Section 113, what it says is that before the trustee can sell or take action to eject a debtor, the trustee must obtain the consent. It doesn't say that the trustee must have the consent. So in my view, it's a sort of one-time condition or a qualifying condition that the trustee has to achieve. And once he's gone through that door, once he's got the consent, that's it. In my opinion, doesn't actually have to do anything else. The other point is that, again, Section 113 isn't intended to be absolute protection. It's only a reasonable protection. And therefore, if a defender or a spouse chooses not to give consent, that's a remedy. They don't actually have to give the consent. But once they do give the consent, my position is that should then be an end of the matter. The other point is that it leads to quite a high degree of uncertainty, because if a trustee has consent, they may think, well, that's fine, we've got consent, we can then go to the next stage. Indeed, they might have a cooperative debtor, or they might put a property in the market, and only at the date of sale might the spouse say, actually, you know what, I've changed my mind, and that would cause all sorts of problems. And The other issue, of course, is that if a trustee has consent, well, it means that they can't then raise an action for consent. So therefore, it's only if a trustee doesn't have consent that you can then apply to the court in terms of section 113. Now, again, a wily debtor or a wily spouse might grant consent with a view to preventing action being taken, and then at the last minute pull that consent away. Now, the decision wasn't appealed, principally on the basis that it was thought that this was a rare occurrence, and in fairness, that's probably correct. But I don't, as I say, I don't think that the decision is correct. It was a decision by a single summary sheriff. It's not binding on other sheriffs. And as I say, for the reasons which are given, I just don't think it is correct. One point I would make, though, at this stage is that if you are drafting consent and having debtors sign them, one point I would make is that you should draft it such that it's made clear that it's irrevocable. Now, that may not necessarily have cured all the problems that the sheriff saw, but I do think that if it's made irrevocable, it's more likely, I think, that a sheriff would agree that in those circumstances it can't be withdrawn, and that a debtor or a spouse might be personally barred from going down that route. The second action was the case of accountant bankruptcy against Allen. Now, this is a reported decision, and I think I spoke about it last year. The background to this was that the debtor had been going through a divorce shortly before the date of the sequestration. And in terms of his divorce, it was agreed that he would give his ex-wife a sum of money, and in return for that, she would transfer her interest in the family home to him. That was fine. The only flying note was that he couldn't get the consent from the secured lender to do that, and the only way that he could do that was to have his now new partner come onto the mortgage with him. So what happened was he and his new partner obtained a new joint mortgage. What then happened was that the funds were then transferred to the wife, and what the wife then did was to grant a disposition not to him, but to him and his new partner. And therefore, he and his new partner were the owners of the wife. Now, the accountant bankruptcy challenged that, and the defence that was put forward in the first instance was that this was a gift that was reasonable to make. And you might recall when I spoke about this last year, the sheriff at Dundee held that no, that wasn't a gift that was reasonable to make, especially when tested against the wording of the section itself. If you look at the section, it talks about birthday, Christmas gifts and gifts of a conventional nature. So it anticipated that sort of gift, not the transfer of a whole house or even half a house. So on that basis, decree was granted. What then happened was that the debtor and his new partner appealed. Before they appealed, they said, yeah, do you know what, the sheriff was right. That wasn't a defence, but we've got another defence. We want to argue that we have given, or rather that the new partner had given consideration. That consideration being that she had become a co-obligant to the security, and that in effect was the consideration that she had given. And I should say that that's sometimes a defence that is presented to us, and it's quite useful that in this particular case, Sheriff Murray held that no, it wasn't valid for a number of reasons. The case went to debate, and as I say, he rejected that defence on a number of grounds. The first ground was that essentially the debtor hadn't got what it was he was supposed to get, and by that I mean in terms of the court decree. In terms of the court decree, it was anticipated he would pay a sum of money to his ex-wife, and in return for that he would then have a whole house. But the way that the transaction was structured, that didn't happen. He paid over a sum of money, and he was left with half a house because the other half of the house had gone to his new partner. Another point was that as a combination of the way that they had structured the deal by getting a new mortgage and paying money, the whole effect of that was that not only did he not have what he was supposed to have, he also had additional borrowings. And so therefore, the net result of this transaction was that, if anything, he was in a worse position than he would have been had title simply been transferred to him in terms of the court order. And the net estate that was available for creditors had been diminished. And in fact, creditors had been increased because there was a liability to the new secured lender. And again, the fact that the new partner had become a co-obligant, and the sheriff didn't consider that to be adequate consideration in all the circumstances. And so therefore, applying, you might recall in the case of Grampian McLennan, which seems to have overturned the law in relation to gratuitous alienations. The point was that when viewed from the perspective of the creditors, this was not a reasonable transaction in all the circumstances, and therefore the sheriff held that no, it failed, no adequate consideration had been given. The third case that I want to talk about now, I can't remember whether or not I did discuss this last year, but I'll mention it again because it's quite useful. The case was a case coming out of a Stranraer Sheriff Court, and the background to it was that the debtor was sequestrated in November 2017, and the warrant to cite was granted on the 23rd of October 2017. As you know, the agent is obliged to, or a trustee is obliged to, register a memorandum in order that the inhibitory effect of the warrant to cite can be continued beyond 3 years. And so what the trustee must do is do that within the first 3 years, otherwise potentially bad things happen. Now, in this particular case, what happened was that the agent for the IB had sent the application for renewal to the keeper, Timmisley, but because there was a discrepancy between the copy that the Sheriff Clerk had sent to the register in the first instance and the copy that was sent by the trustee, the keeper rejected the application and sent it back. The agent was flummoxed by that and checked with the Sheriff Clerk, and it turned out that the Sheriff Clerk had made an error. And so, armed with that knowledge, the agent went back to the keeper and said, look, the Sheriff Clerk has botched this up, would you consider it? The keeper said, yes, you're quite right. The Sheriff Clerk did indeed make a botch up, but you're now too late to put your application in because it's more than 3 years. And so in that particular case, what we had to do was make an application to the sheriff to declare that, in fact, title had been, or that the application had been made timorously. And indeed, it had been made timorously. An application had been made to the keeper within 3 years. There was clear evidence of that. And so, on the back of that, the sheriff granted the declarator and granted various orders that allowed the keeper to register the order in the register. And the reason why he was able to do that is, if you recall, the terms of section 112, all it requires, amongst the various steps that a trustee has to take to avoid the effect of property revesting in a debtor, there are various steps that a trustee has to take, but one of which, in relation to renewing the memorandum, is to send it. It's not necessarily to have it registered, it's to have it sent. And on that basis, the sheriff was prepared to grant the order, and the matter was solved. This could be contrasted with the case of the Inrocas against Rose. And in that case, the application to renew was simply late. And so in those, that was a case where an attempt was made to use revisions of section 39A to ask the sheriff to extend the period. And unfortunately, the sheriff at Banff Sheriff Court, I think it was having none of it and wouldn't renew it. But in these circumstances, or rather circumstances of the case from Stranraer, it was completely different, because it was evidence that it had been sent timorously rather than not having been sent at all. The moral of the story, though, is always just to make sure that you never have to rely on these provisions. And I've said it time and time again, but make sure that your diary system is up to date, so that you don't forget to register these things timorously, and that you continue to renew them. So with that salutary warning, I'll pass you back to Shona.